not believe in causation?
Well, I mean, there's more than just that. There was also some sort of an underlying conspiracy to assassinate Lincoln in the first place.
So what? I'll prosecute all of them. I'm not saying only the grandparents. We'll round them all up. Anyone who we can show caused this, we're going to prosecute them. And sure, get the conspirators too. Get Dr. Mudd. I'm good with that. Why not?
Because they weren't the actor?
They weren't, so only the actor. Like, so the co-conspirators, we're going to let them off. Well, that seems shaky.
In a way, they're kind of not like the direct Charles, they're the direct.
Good. What we want, right, if we have going to think of this as a chain, right? That's not a bad chain. Now think of this as a chain. In the chain of causation, get used to that phrase. You're going to hear it here. You can hear it in torts until you're sick of it. If we're going to think of this chain of causation, and anything, you don't even get on this chain unless you're at least a but-for cause. So the first thing we're going to look for is but-for causes. They have to at least be that. That's like the minimal threshold you can get in the game. But that's not, it clearly can't be enough by itself. Right? So we've gone through the door, we've at least said, yeah, it was but-for. We can start with that. What we want is some place to draw the line between the but-for causes that we're going to say, no, those don't count for criminal culpability. Those are too remote. And what we call direct or proximate causes. That is our, that is our holy grail. What we are looking for is how the law defines the threat. All proximate causes are but-for, but not all but-for are proximate. So what we're looking for is what rules, what tests, what factors make a cause not just but-for, but proximate. Those are the ones that we can use, that we can prosecute over. Okay? So we're not going to prosecute Abe Lincoln's grandparents, John Wilkes Booth's grandparents, but we might prosecute John Wilkes Booth and his conspirators. Okay? Okay. Any other questions about this? And I don't mean to, I just want to introduce this for now. We will get into what those factors are as we move through these cases. What makes a cause actually proximate. So here's the place to at least start the consideration of that. All right, let's talk about Benji. There was a fatal railroad accident. No one likes to hear about those. And this is at Staplehurst, 2 miles towards London from the Headcorn station. How did this happen? How did this awful thing happen?
So, the defendant was a foreman of a crew that was sent to replace the tracks. He had a book that told him when the train would be coming in and out of the schedule. This is supposed to aid him to when different sections should be repaired.
Because you don't want to pick up the tracks to replace them when a train is due. Because that's bound to lead to not such good results. So you need to know when the trains are due, right? And make sure one is not coming during the time you're going to need to get the job done. Okay?
So, the defendant misread the book. He looked at Saturday instead of Friday and decided to take up a part of the tracks that was needed less than a half an hour before a train was due.
So that's on Friday. On Friday, when was the train due?
3:15.
So here's our sequence. On Friday, train due at 3:15 to come through. And when does he order the tracks to be taken up?
He orders it after the last train passed at 2:50.
So prior train, 2:50. So between 2:50 and 3:15, Benji orders tracks lifted. Okay? And he does this because he read the date for Saturday. And when would the next train have been due after 2:50 if it was Saturday?
I believe it was 5:20.
That's right, 5:20. And that would have been plenty of time to get the work done if he had, if this had been Saturday and he had ordered it around 3, let's say 2:55, he would have had plenty of time to get it done, have it be safe before 5:20, but he didn't have anything close to enough time before 3:15. So reading the wrong date was a really bad thing, okay? So what then happened, or to put it another way, what didn't happen in addition before the train got there?
So, it is a rule that there must be a flagger, 1,000 yards out from where the work is going to be done.
And in the direction the train is coming from,
Right.
right?
And, the flagger should be seen by the train by 500 yards, giving a total of 1,500 yards or nearly a mile for the train to stop before the tracks ran out.
And
So
what happened instead?
The person that Benji sent only went like 500 feet, and so the train couldn't stop in time.
And so when he saw the train coming, 500 yards in the distance, it was way too late, okay? And so what happened?
The train derailed and killed a bunch of people.
And as the court puts it, I love this language, the catastrophe ensued in which many lives were lost, okay? So what did Benji's lawyer argue in what seems like what did he argue?
He argued that the death or the conviction should be dependent on whether the death was mainly caused by the defendant.
More simply,
He was the sole cause.
is that what Benji's lawyer argued? Would you want to argue that if you were Benji's lawyer? Oh yeah, my client was the sole cause of their death.
He's trying to say that the other causes of the death should be considered.
He did not cause the death, and what's his basis for that? Because, I mean, look, Benji did this. Isn't it true that without Benji doing this, the train would not have derailed? So don't we have but-for causation?
But he also says that because the flagger didn't do what they were ordered and the train conductor didn't use reasonable care to stop as well, they have also had causation.
He says, look, even with the mistake that Benji made, the accident could not have happened without somebody else's mistake. So my client's conduct was not a sufficient cause standing alone, because the flagger should have prevented it. If the flagger had been where the flagger was supposed to be and caught it in time, and by the way, who else screwed up?
Didn't they say that the conductor didn't realize it in time or something?
The conductor also screwed up, according to Benji's lawyer, and that was also a reason why that even given the tracks, the accident shouldn't have happened but for other people's mistakes. The conductor should have hit the brakes more quickly, okay? Doesn't this sound a lot like Martin Dios?
Yeah.
Right? Martin Dios, he didn't alone cause the deaths. Here Benji is saying my client didn't alone cause the deaths. The actions of others did as well. The actions of others, whoever inflicted the other injury. And so it can't be said that Benji's actions alone would have resulted in the deaths of the train accident without the contributing actions of others. So, Ms. Cull, same result?
No. He was found guilty.
No. So wait a minute. Seems like the same setup and we get a different result? Does that have you already wishing you'd never come to law school when you see stuff like this? Just a little. Okay, I'll take that. When we don't get the same result, we got to ask, well, what was different? Now, sometimes the answer is going to be nothing's different. These courts just reach different results. And that gives you the opportunity to say, here's the case I would use to argue this, how it should come out, even though the setup is the same if I was representing the prosecution. And here's the case I would use if I was representing the defense, because courts just disagree, apply the law differently, think the principles should be different. Is there a difference here that you can use to actually distinguish these cases?
I think the difference is that the defendant caused the situation, so if he hadn't have misread the plans, he wouldn't have had a need to send the flagger out, and at that time, the conductor wouldn't have needed to stop, and therefore caused the whole situation.
Excellent, excellent. The difference, if you're gonna buy one, right, and if I were lawyer for Benji, I would certainly want to rely, if it had existed at the time, it didn't, but if it had Martin Dios, it came a century later, but if it had Martin Dios, I certainly want to rely on it. But if there is a difference in between them, it's that, remember one of the things we could say in Martin Dios, that we could not even say that Martin Dios, that his injury was a but-for cause of the injury, certainly not beyond a reasonable doubt, right? If Martin Dios's injury came first, and RM could have recovered from it, then Martin Dios wasn't even a cause of the death, right? Didn't materially cause the death. Here, the court says, or at least the jury could decide, that even though there may have been other causes, Benji's was a cause of death. And so what instruction does the court give the jury that it must find?
That the verdict must be dependent on whether the death was mainly the cause of the
Good. The trial judge, main cause or principal cause, trying to at least begin to develop this idea of a separation, a line between indirect causes, remote causes, and the most direct causes, the principal causes. Now, this is not ultimately where we're going to end up in terms of the doctrine of proximate cause, but you can see what the court is getting at, how this is a first pass at trying to draw this line.
So what the court's saying here is that the mistake with the schedule was a necessary cause in order for any of the other causes to even happen.
Well, you don't even get in the game if you can't say it was a necessary cause. That doesn't mean it was sufficient by itself, right? It couldn't have happened, thus it was necessary. The whole thing couldn't have happened if Benji hadn't done this. So it was necessary to the bad outcome. But basically, Benji's argument, well, it wasn't sufficient by itself. There were other causes, so you can't hold him culpable. If you were a prosecutor and you heard that argument, there were other causes, so you can't hold Benji culpable. What would your answer be in a nutshell? Really, like.
If you removed either of the other individual causes, it still would have happened. If you removed what he did, it would not.
Even more, that's good, that's really good, but even more simple than that.
Well, like you said, everything is caused by something else, and so at that point, can you hold anyone criminally responsible because something else?
Good, excellent, and the court rejects his argument because if you're going to let contributing other causes let Benji off the hook, then all the other causers might in their turn make the same excuse, and so if it was valid, no one could be criminally culpable at all. So if I'm the prosecutor, I say, there were other causes, we'll prosecute them too. And there can be multiple causes, all criminally culpable. But you have to be able to show, now it's hard to argue there are multiple principal causes, but there can be enough, right? let's say two people shoot at the same victim at the same time, right? It's a hit, and whoever hires the hitman hires several of them, several hit people, to go out and make sure the victim gets what they deserve, right? All of the shooters can be culpable, even though one might have been sufficient, okay? Because if they were sufficient, which was not true in Martin Diaz. Okay? Questions? Yeah.
I just had a question about how these cases are different than, and I know we haven't gotten to it yet, but how these cases are different in terms of why they aren't classified as intervening events for limiting causation. Because these seem like involving intervening voluntary acts that might also, unless that was the argument there and we got that disproven in Benji, but I'm not exactly sure how that works, or if they just go hand in hand, or if they don't at all.
Intervening, well, we can just move to Hubbard to do that, I guess. Intervening or superseding, if you prefer, causes. Can we talk about that in the context of Hubbard? Because we're gonna,
Yeah.
because
Yeah.
that case is our first encounter with that concept. So let's see if we can answer that with Hubbard.
Okay.
Okay? This is our first Kentucky case. Right? This is a Kentucky case. And when does it take place?
1947,
1947. What's going on around this time, or has been going on?
World War II.
World War II has just ended. And in fact, when the events take place, it's August of 45. So the war really is just ending. And tell me about what's going on with Hubbard in August of 1945.
So he was on a leave of absence from the war, and he was arrested for being drunk in public.
So wait a minute, a soldier was home on furlough and he got drunk? That's hard to believe. I'm skeptical. No, you're absolutely right. He was arrested for being drunk in a public place. Now, how drunk was he?
He was so drunk that he couldn't be sentenced.
He couldn't even be tried, right? They had to let him dry out first. And every time I read this case, every time we get to it in the semester, I am reminded of the Andy Griffith Show.
Yes.
Why? Why am I reminded of the Andy Griffith Show?
Otis, he's the town drunk. He goes there every weekend.
Floyd, right? Floyd, the town drunk.
No, it's Otis.
Has to, they put him in the jail. Pretty much the only prisoner who's ever in jail in Newberry to dry out, right? So I think of Hubbard as Floyd, but that's just me, and maybe that just shows how old I am that I remember the Andy Griffith Show. So what happens when they try to send him to jail to dry out so at least he can be tried?
So he resisted arrest, and he started, and then he punched Mr. Newman.
And
They tried to hold
we don't
him.
care so much about Newman, do we?
Yeah, and then when he punched him, he held him until he was. So he tried to hold him until someone else took place, and then Deesh started saying, "Oh, I'm not feeling well, and I gotta get out."
And how did they finally get Hubbard restrained and off to jail?
2 or 3 people,
Including the judge. The judge has to actually convince Hubbard to get off the floor, and then he still resists as they lead him off to jail. So Deitch is in distress after struggling with Hubbard for a while, and he's holding on, and he's holding his hand over his heart. He sits down for a few minutes, tumbles to the ground, and dies within a half hour. Really bad stuff, right? So you're defending Hubbard. What are you going to point to in all of this to say, look, my client's not guilty, at least not of this?
So they said that he was
in fact, Hubbard never struck him, and he didn't cause any physical injury. Okay? So, does that work for you at trial? Pointing to those facts about, Hubbard, Deitch had this condition, and your client didn't strike him. There was a struggle. Deitch was trying to hold on, but he didn't hit him. He didn't cause any injury the way, say, Martin Dios caused an injury to RM. Does that work at trial?
No.
No. What happens?
He was charged for murder.
Well, voluntary manslaughter. It wasn't quite murder. And he's convicted. What happens at the Court of Appeals? What happens?
The Court of Appeals, they said that basically the verdict was like it was too proximate. It was not direct enough or proximate enough for the causation to.
Why not?
Be in place. Because when the doctor said that the reason why he died was out of excitement. Well, he was gonna die anyway, but then the excitement caused an acceleration of his death. So whether he was there or not, he would have died anyway. And
But
he
we
didn't-
know from Benji that simply because other factors, other than the actions of the defendant, contributed to that harm, doesn't get him off the hook, right? The fact that Hubbard had an existing condition, Deitch rather, had an existing heart condition. Why isn't that like the actions of the flagger in Benji, which didn't get Benji off the hook?
Because he had a pre-existing heart condition.
He was what?
But for the pre-existing heart condition.
No, you could argue that same argument in Benji.
Because in Benji, they had like an indirect action, and this one, the court says that it would be unreasonable or unsafe to like convict someone because of they cause fright, fear, or terror.
What is the nature of Hubbard's actions that the prosecution is trying to use as the hook to hold him culpable, Ms. Richter?
Well, the court's trying to say that he caused the,
Tell me what the prosecution.
or the prosecution's trying to say that he caused the guy to get excited, which aggravated this heart condition.
And what does the court say is wrong?
The court says because it wasn't a probable and natural consequence of
Probable and natural consequence. And why would we want to hold Hubbard culpable only if the outcome that he caused was a probable and natural consequence of the action he took? What is the natural, what would we say the death of Deitch wasn't?
It wasn't just because he was being routed when he would be contained.
No, what wasn't that outcome? From Hubbard's point of view, what would you say about that outcome? What wasn't it?
It's a direct result of this.
Well, let's assume it was a direct result, but what wasn't it? It wasn't foreseeable. A huge element in when we look at an intervening cause, it may be that which makes something not foreseeable. But here, it wasn't foreseeable, the court says, for several reasons. That's not very likely to happen. You resist arrest, it's not likely that someone's going to have a heart attack. Right? And the court says what he did was only a misdemeanor, not of a character likely to endanger life. Another way of capturing sort of one of the aspects of foreseeability. And that's how you distinguish Benji. If you create this danger, that is likely to endanger life. That was foreseeable. If you do this wrong, that is exactly the consequence that is likely to result. Tragedy with a train accident. The court says with Hubbard, his actions were bad. They were a misdemeanor. You don't want to resist arrest, but they're not likely to cause this harm. I mean, what percentage of the time is somebody gonna have a heart attack while subduing a prisoner who's resisting arrest? Now, if you happen to resist arrest, resisting arrest can take a lot of different forms. If your resisting arrest takes the form of shooting the police officer trying to arrest you, then that is likely to cause harm, but not so here. Okay, we will talk a little bit more about Hubbard on Monday, and so I will see you then.